All right, let's get right into it. We're about to unpack the last 25 years of internet law. We're going to see how one simple idea meant to help the internet grow ended up creating a massive multi-billion-dollar headache. And now, that very same legal fight is shaping the entire future of artificial intelligence.
I mean, it's happened to all of us, right? Well, the reason why has everything to do with this fundamental clash, a tension that the internet basically blew wide open the second we all got the power to click upload.
So you've got this constant tug of war. On one side, you have creators' rights, the totally fair idea that if you make something, you should be able to control it and get paid for it. But on the other side, you've got internet freedom, this powerful belief in sharing, remixing, and open access to information. For decades now, lawmakers, especially in the EU, have been trying to strike a balance between these two huge forces.
So here's the game plan for this explainer. We'll kick things off with the internet's very first crack at solving its copyright problem, the safe harbors. Then we'll see how that led to something called the value gap, which sparked the huge Article 17 showdown. And finally, we'll see how all of this connects directly to the new frontier, AI and its endless appetite for data.
Okay, let's rewind the clock to the year 2000. The internet is still kind of the Wild West. It's chaotic, it's new, it's exciting. But it has a potentially fatal flaw. If every platform was legally responsible for every single copyrighted thing its users uploaded, they'd be sued into non-existence before they ever got off the ground.
So, the EU came up with a really clever solution in its e-commerce directive. It was called the safe harbor principle, and the idea was actually pretty simple. If you run an internet platform, you are not on the hook for what your users do, unless you actually know they're doing something illegal. Think of it like this. Early internet companies were basically treated like highway operators. They built the roads, the digital infrastructure, but they weren't held responsible if a driver, a user, decided to speed or break the law on their road. This protection was absolutely crucial. It let them build the web as we know it without having to constantly police every single user. And this wasn't just a vague idea. It was spelled out with specific legal shields. You had Article 12, which covered just passing data along. Article 13 handled caching, that temporary storage that makes everything load faster. And the big one, Article 14, protected platforms for actually hosting user data. To top it all off, Article 15 made it crystal clear. Platforms had no general duty to snoop on what everyone was doing. This was the legal bedrock that allowed the internet to absolutely explode. But let's fast forward, say 15 years. The internet looks completely different. Those little digital highways, they've turned into global empires. Platforms like YouTube and Facebook are making mind-boggling amounts of money, mostly from content uploaded by users. And the people who actually created that content, they started to feel like they were getting a raw deal.
This brings us to a term you started hearing everywhere, the value gap. It's pretty much what it sounds like. It's the massive gap between the fortunes the platforms were earning from all this creative content and the tiny, tiny fraction of that money that was actually making its way back to the artists, the musicians, and the filmmakers who made it in the first place.
And when you see it visually, the problem is just stark. Platform revenue was shooting through the roof, but the payments to the creative community were staying frustratingly low. This huge imbalance became the #1 reason for a major push to rethink that whole safe harbor system.
So, the stage was set for the single biggest earthquake in EU internet law in a generation. It was called the Copyright in the Digital Single Market Directive, but everyone just knows it by its most famous and controversial part, Article 17. And it was all about shifting the blame.
Article 17 flipped the entire model completely on its head. For the very first time, it made big online platforms directly liable for copyright infringement committed by their users. The safe harbor? For them, it was pretty much gone. The law now said they weren't just neutral highway operators anymore, they were actively involved in communicating that content to the public. That is a huge change.
And this created a whole new rule book for platforms. First, they have to use their best efforts to get licenses from copyright holders, okay? But if they can't get a license, then they have to make sure that specific unauthorized stuff doesn't get uploaded in the first place, which, let's be honest, means upload filters. And on top of all that, they still have to run a super fast and effective notice and takedown system. And this quote just nails the impossible position this puts platforms in. It's a total catch-22. If you filter everything really aggressively to keep the rights holders happy, you're going to tick off your users by taking down their memes, their parodies, their reviews. But if you don't filter enough, you're breaking EU law and angering the very creators whose work makes your platform valuable. There's no easy way out.
So just when everyone was getting their heads around the Article 17 fight, a whole new technology comes along that presents an even bigger, more fundamental challenge to the very idea of copyright: generative AI.
Here's the core issue. For an AI model to learn how to write or create images, it needs to see, well, pretty much everything. These models are trained by scraping unbelievable amounts of data from the open internet, which, of course, includes billions of copyrighted photos, articles, and songs. So the trillion-dollar question is it actually legal to copy the entire internet to train an AI?
Well, the EU's answer, which, funnily enough, was written in that same 2019 directive before generative AI really exploded, comes down to two legal tools. They're called text and data mining exceptions, or TDM. Basically, they give you permission to copy stuff for computational analysis. But, and this is a huge but, there's a catch.
The law creates two different lanes. Article 3 is the for science lane. It gives a really broad, powerful exception to nonprofit research groups and universities. But then you have Article 4. That's for everyone else, and that includes the big for-profit AI companies. The crucial difference? Under Article 4, copyright holders can opt out. They can put their hand up and say, nope, you can't use my work for commercial data mining.
But this opt-out idea just opens up a giant can of worms. Seriously, how do you even do it? Is a little line buried in your website's terms and conditions enough? Or does it have to be special code that a machine can read? What happens if someone reposts your opted-out photo on a different site that doesn't have that notice? Does the opt-out travel with the image? These are the messy, unanswered questions that lawyers for AI companies and creators are fighting about right now.
And that brings us to today. We're right in the middle of yet another great rebalancing act. The tech just keeps leaping forward, and the law is desperately trying to jog alongside it, searching for that fair and stable middle ground. This quote from one of the sources really gets to the heart of it all. For the longest time, we've had this triangle of competing interests, right? You've got users who want freedom, rights holders who want to be paid, and the platform stuck right in the middle. But now we have to add a whole new corner to that shape: the AI developers who need access to all of our cultural data to build the future.
So let's just recap this wild ride. In 2000, we got safe harbors to let the internet grow up. By the 2010s, that growth created the value gap. In 2019, Article 17 tried to fix it by moving all the responsibility onto the platforms. And today, the sheer data hunger of AI has ripped open an entirely new and even more complicated chapter in this never-ending race between technology and the law.
Which leaves us with one last massive question to think about. If these new AIs are literally learning from the sum total of human culture, our art, our stories, our music, our code, then who gets to decide what goes into its curriculum? Who curates the syllabus for the most powerful learning machine humanity has ever built? The answer to that question is going to define the next era of the internet.